What do I have to prove if I'm hurt in a trip and fall accident? In Maryland, if you're a guest on someone else's property, they owe you a duty to keep the property reasonably safe and to keep from injuring you. In the example of someone who's like a guest in a store, that person is called a business invitee. The landlord or the owner of the property has the duty to make sure that they keep the premises in a reasonably safe condition. They're not an insurer of your safety, but they do have to take reasonable steps to make sure that the property is free from defective and dangerous conditions. If they find a dangerous or defective condition on their property, they can do one of two things. They can put up a warning sign, like if you're in a grocery store, they could put a sign up near a spill of water. Or they can correct the condition. Same example, if you're in a grocery store and there's a puddle of water, the owner of the property could have somebody mop that water up. They would put up a sign for the remaining wetness on the floor to warn you of that until that dries up. If the landlord does not take reasonable steps to ensure that the premises are safe and there's a defect on the land, the court will find that they had constructive notice of that defect or that dangerous condition, unless they actually created it, in which case they would have actual notice. But notice is the final requirement. Did the landlord or the property owner know of the dangerous condition, or should they have known, in enough time to be able to do something about it? If all those things are true, are found to be true by the court, then the owner of the property will be held liable for your injuries.